Hi everyone, my name is Beth Brown and I am counsel in the pensions group at Mayer Brown. Welcome to this episode. In these episodes, we cover different topics each month, providing an overview of the issues faced by pension industry practitioners and offering some practical insight. The time spent listening to these episodes can count towards solicitors' continuing competence and PMI CPD requirements. All the episodes are available on our Mayer Brown YouTube channel, as well as iTunes, Google Play and Yahoo. You can also subscribe to this channel so that new episodes are shown automatically in your subscriptions feed. Hi everyone. In this episode, I will talk about the new regulations relating to one of the new grounds for issuing a contribution notice, being the Employer Resources Test. Before the Pension Scheme Act 2021, in respect of a defined benefit pension scheme, the regulator could issue a contribution notice against a scheme employer or those associated or connected with that employer if it was reasonable to do so, where there had been deliberate avoidance of a Section 75 debt or an act or failure to act materially affected the likelihood of members receiving accrued benefits, and such an act occurred in the last 6 years. There is a statutory defence to the material detriment test, which is the person who could be subject to the contribution notice gave due consideration to the extent to which the act or failure to act might detrimentally affect in a material way the likelihood of accrued scheme benefits being received, and either concluded that there would be no material detriment or took all reasonable steps to minimise the potential detrimental effect. The Pension Scheme Act, which became law on the 11th of February, introduced two new grounds on which the regulator can issue a contribution notice, which in essence makes it easier for the regulator to issue a contribution notice. Very broadly, the Act introduced the Employer Insolvency Test, which allows a contribution notice to be issued where immediately after an act or failure to act, if the employer was to suffer a hypothetical insolvency event triggering a Section 75 debt, and the regulator is of the opinion that the act or failure to act materially reduced the amount of the Section 75 debt which the scheme could recover. And two, the Employer Resources Test, which allows a contribution notice to be issued where the regulator is of the view that an act or failure to act would have reduced the value of the employer's resources, and this reduction is material relative to the estimated Section 75 debt in relation to the scheme. Whilst the Act widens the grounds for imposing a contribution notice, it is important to remember that the regulator must still establish that it's reasonable to impose a contribution notice. There is also a statutory defence to both these new grounds, where a person gave due consideration to the act or failure to act and took all reasonable steps to eliminate or minimise the potential for the act or failure to act to have that impact. As with the other provisions in the Pension Scheme Act, the detail is to be set out in the regulations, and these provisions are no different. The draft regulations were laid before Parliament in June, and now we have the final set of regulations, the aptly named Pensions Regulator Employer Resources Test Regulations 2021. So doing exactly what it says on the tin. I'm going to summarise the contents of the regulations in this episode, but before I move on to doing that, I just want to make one final point by way of scene setting, and that is that another change that the Pension Scheme Act introduced is the failure to comply with a contribution notice is now a criminal offence, punishable by 7 years in prison or a fine up to £1 million, which is in addition to the regulator's ability to issue a penalty fine. So moving on to the regulations which came into force on the 1st of October 2021 set out what constitutes employer resources and how they're valued for the purposes of the new Employer Resources Contribution Notice ground. Essentially, when considering an employer's resources, what will need to be considered are the profits of the employer before tax, as stated in the employer's accounts, adjusted for non-recurring and exceptional items, i.e. infrequent or unusual items. When categorising an item as non-recurring or exceptional, and considering any value, the regulator will have to have regard to the relevant accounting standards published by the Financial Reporting Council Limited. If there are no suitable accounts available, for example, maybe because the employer is not required to prepare annual accounts under the Companies Act 2006, the regulator may determine, calculate and verify the value of the employer's resources. In undertaking any assessment and calculations, the regulator must take account of all relevant information and, provided it does so, no further verification is required. In practice, particularly while the Employer Resources Contribution Notice ground is new, I expect that employers will pursue the regulator clearance application route more often, although this may happen less once more is known about the new test. Employers will be pleased to know that the regulator has just published a draft revised Code of Practice 12 covering circumstances in relation to the material detriment, employer insolvency and employer resources test to set out the circumstances in which it expects to issue a contribution notice. This draft Code of Practice includes some helpful illustrative examples. While we are waiting for the dust to settle on this new contribution notice ground, I think companies where a company in its corporate group participates or has participated in a defined benefit pension scheme should consider the impact of any material business activity on the pension scheme and make sure they keep a record of the reasons that a decision to proceed with the business activity, having given such pension scheme due consideration, was made. All that is left to say is Happy Halloween and thank you for listening. This episode is an overview of the law in this area, and how the law will apply in any particular case will depend on the individual circumstances. Please therefore remember to seek legal advice on your particular circumstances.